네, 저희 시작 전에 잠깐 기념사진 먼저 찍고
Before we
시작을
begin, we
하겠습니다.
will take a commemorative picture.
afternoon, distinguished guests, ladies and gentlemen. A very warm welcome to the 16th Asia Legal Information Network's International Conference. My name is Hyo Young-gong from Korea Legislation Research Institute, the Alin Secretariat. I would like to extend our sincere gratitude to our distinguished guests, online and offline, for taking time to attend today. And also a special thanks to moderators, speakers, and panelists of the conference. The ALIN International Conference is held annually in one of the countries of ALIN members in turn. And this year, the 16th ALIN Conference is taking place in Seoul, Korea, hosted by Korea Legislation Research Institute and Asia Legal Information Network. And for the first time, this conference is also held online and broadcasting at the official conference website, www.alinevent.com. And if you have troubles in access to this website because of heavy traffic, then you can also watch this conference on YouTube. Just type in ALIN Conference. So we would like to ask you to join online and then share your thoughts by leaving comments and questions and live chat on the YouTube and the official website. Then your questions and comments will be delivered to speakers at the end of the conference for answers. Now, we hope you to leave this conference with your participation, and then let us to start the 16th ALIN International Conference on Laws for Fading Borders in Asia. I would like to now invite Mr. Kae-hong Kim, President of Korea Legislation Research Institute, to open this conference. Please welcome Mr. Kae-hong Kim.
안녕하십니까?
Ladies and gentlemen, good afternoon or good morning.
아시아법령정보네트워크의
I
사무국인
am Kae-hong Kim, President of the Korea Legislation Research
진행됩니다.
Institute, the
반갑습니다.
Secretariat of
오늘
ALIN.
이렇게
I'm
전
delighted to meet
세계적인
you all
어려움
today.
속에서도 온라인으로 제16차
I would like to
알린
start by expressing my
국제학술회의에
appreciation to all of
참석해
you
주신
for
여러분께
taking time to
감사
attend this
인사를
conference during the global
이
COVID-19
축사를
pandemic.
위해서
My
귀한
special thanks
발걸음을
go
해주신
to
서울대학교
Emeritus
권호승
Professor
명예
Oh-seung
교수님
Kwon at Seoul National University
오늘
School
기조
of
연설을
Law,
맡아 직접
and
현장에
also
와주신
our keynote speaker
고려대학교
who is here with us today,
법학대학원의
Professor Asif Qureshi at Korea University School of Law.
또한 해외에서
I am also
온라인으로
grateful for all the
자료를
presenters and
준비하시고
discussants
발제해
joining
주시는
us online from
발표자,
abroad,
토론자와
as well
국내
as the local
함께
discussants who are present here
해외에서
today at the
실시간으로
venue,
본
and
컨퍼런스를
also all
접속해서
other participants
시청해
joining
주시고
us from
질의를
overseas
해주실 수많은
online to
참여자께도
engage in the
감사의 말씀을
conference
드립니다.
with your insight.
올해는 아시아법령정보네트워크의
This
사무국인
is
한국법제연구원이
an important
개원
year for
30주년을
Korea
맞는
Legislation Research Institute, or
여러
KLRI,
회원국에서
as it marks its
회의
30th
개최를
anniversary.
자진하여 주셨지만
And
특별히
to
저희가
celebrate
서울에서
this
개최를
historical
계획한 바
milestone,
있습니다.
we offer to host the
코로나
conference in Seoul
팬데믹으로
this year,
안타깝게도
although there were
여러분을
many other countries who
직접
volunteered to
서울에
host
모시고
this year's
도심
meeting.
한복판의 궁궐에
I would like to
드리워진 서울의
take this
서울의
opportunity to
가을과
thank all the members, and
강남
it is
마천루
regrettable
가운데
that due to the
뻗어가는
global pandemic,
K-culture를
we are not
소개하면서
able to have you here in
한국의
Seoul
음식을
and take you on a
대접해드릴
tour to
수는
ancient palaces
이렇게라도
downtown to show you
온라인으로
the autumn of
서로
Korea
얼굴을
or
보고
the skyscrapers in
학술 연구와
Gangnam.
서로의 법령
However,
정책을
I am
공유하면서
very
생각을
delighted that
나눌 수
we'll be
있는
able to
감사해야 되겠습니다.
share our thoughts on legal and
코로나
policy
바이러스는
issues
안타깝게도 눈에
online.
보이지 않습니다. 그래서
Unfortunately,
더 두렵게 만듭니다.
COVID-19 is not visible to
어느
your
분이
eyes. That's what
감염됐는지
makes it even
드러난다면
more
통제가
fearful.
매우
If you
수월하겠지만
can see with
그렇지
your
않다는
eyes
점이
who is
우리를
infected and who is
더욱더
not
불안에
infected,
떨게
it
하고
would be
있습니다.
much more easy to
코로나
control this
바이러스는
pandemic, but that's
국가를
not
가리지
how it is.
않습니다.
Also,
사람을 매개로 전파되는 것이니
COVID-19 does not
국경을
discriminate
봉쇄하면
nations. It goes
되지 않을까
beyond
하지만
borders. And
경제
that
사회적으로
is
긴밀히
why
엮여 있는 현대사회의 특성상
simply shutting down
무조건
borders cannot be a
봉쇄하는 것도
solution
녹록하지가 않습니다.
to the
오히려
COVID-19
국가 간의
pandemic.
협력과 연대로
And therefore, it
코로나
is
위기를
really
극복해 나가는
important for
노력이
the
그 어느
countries, the state
때보다도
actors, to work
절실히
together and
필요한
collaborate in
때이고
order to
강조돼야
address
되겠습니다.
this crisis of COVID-19
그럼에도
pandemic.
국경의 의미가 퇴색되어가는 이 시대에
At this time, when the
아시아 지역
borders are
각국의
fading,
법령은
it is
어떤 역할을 수행해야
meaningful
되는가
for us to
하는
gather
점이 오늘
here
컨퍼런스의
to
화두입니다.
study the changes in laws in different
이주의
Asian
문제에서
countries.
시작하고
We begin
경제,
with the
무역의
topic of
측면과
migration, and we'll
인권에
also
대한
talk about
이슈까지
economy, trade,
오늘
and
여러
also
국가의
human rights.
발제자들께서
We will be covering
심도 있는
various
발표를
topics
해주시고
thanks to the
그에 따른 전문가의
presentations,
토론까지
as well as
이어
discussions
들어보도록
by
하겠습니다.
expert panelists.
오늘 컨퍼런스는 팬데믹의 시대에
In this era of pandemic, this conference will be an opportunity for us to reconsider the meaning of
국경의 일시적인
borders.
폐쇄가 있지만
There are currently temporarily
장애가 있지만
closures
그러나
of
그게 지속되지는 않을
cross-border
것이고
movement, but I
여전히
do know that it will not
국경의
persist,
문제가
and
퇴색되어가는 그런 경향은 가리라고 생각을 합니다.
And I do believe that the borders will continue to fade as you have more free movement across borders. And so this will be an important opportunity for us to think about our direction forward in the context of each country's legislative and policy system. I hope this is a fruitful session for you all. Thank you very much for your attention. Thank you.
Thank you very much. Now I'm pleased to invite our congratulatory speech speaker, Emeritus Professor Oh Seung-kwon at Seoul National University School of Law. He's also a member of the National Academy of Sciences of the Republic of Korea and was a former chairman of Korea Fair Trade Commission. Please join me in welcoming Professor Oh Seung-kwon.
예, 안녕하십니까? 저는
Yes,
오늘
good morning or
제16차
good afternoon.
알린
It is my
국제학술회의에
great pleasure
참석해서
to take
축사를
part
할 수
and
있게
to
된 것을
deliver
아주 기쁘게
congratulatory
생각합니다.
remarks at the
그리고 이런
16th Alin
기회를
International
허락해 주신 우리
Conference. And I'd like
한국법제연구원
to thank
김계영 원장님께
President Ki-hong Kim
감사드립니다.
of the Korea Legislation Research
올해는
Institute for giving me
코로나19
this
사태가 전
opportunity.
세계를 휩쓸고 있어서
This year, the
국제적인
ongoing
교류와
COVID-19
협력이
global
크게 위축되고
pandemic
있기
has
때문에
taken a significant toll
국제학술대회를
on
개최하기가
international
매우
cooperation
어려운
and
형편입니다.
exchanges,
그럼에도
making it nearly
불구하고
impossible to hold
한국법제연구원이
international conferences nowadays.
제16차 알린 국제
Yet, the Korea
학술대회를
Legislation
이처럼
Research
온라인으로
Institute
개최하는 것을
has been
보면
able to overcome this challenge
국제적인
by
교류
deciding to
협력의 필요성이
host today's
얼마나
conference online.
큰지를 짐작할 수
I find this to
있을
be a
것
highly
같습니다.
resourceful move,
저는
which at the same time
1980년대에
highlights the need for
독일
sustaining international
프라이부르크에서
cooperation and
유학할
exchange.
수 있는 기회를
Personally, I had an opportunity
가졌습니다.
to study in Germany
유럽에서는 그
back in the
당시에 이미
1980s. Even then, at that time, Europe already had the EEC, the European Economic Community, which was a system of regional economic cooperation. This allowed borderless cooperation and exchange to take place routinely within the community. I was also able to take my family to neighboring countries like France or Switzerland on weekend trips. During these visits, I became so envious of Europe for being such a united community, and I hope that a similar arrangement could be possible someday in Asia as well. Since then, after coming back to Korea, I have made wide-ranging efforts to bring that vision into reality by promoting cooperation and exchange with scholars from other Asian countries and joining in efforts to build a legal framework for sustainable regional cooperation and exchange. Over the years, we have made big strides in making borderless cooperation and exchange possible in Asia, so it falls far short of what is possible in Europe. Part of the reason for this is that we face a far greater number of hurdles against cooperation and exchange than in Europe. One of these obstacles is a wide disparity in laws and institutions. Laws and institutions can be used either to foster international cooperation and exchange, but at the same time, it can also restrict them, so it's like a double-edged sword. This is why it is imperative for legal experts like us to come together and compare our respective laws and institutions organizations in an effort to identify and remove impediments to international cooperation and exchange while reinforcing elements to foster them. Such efforts are vital to establishing a legal foundation on which cooperation and exchange can take place without restrictions in Asia. In this respect, I'm highly appreciative of the role ALIN has played in boosting international cooperation and exchange in the field of laws and institutions through diverse initiatives, including this international conference, which is now in its 16th year. And I applaud the bold decision made by ALIN to sustain this tradition by holding today's conference online under the theme of Laws for Fading Borders in Asia, so that we can discuss common challenges faced in Asia in immigration, trade, competition, human rights, and so on. I think yours was a very wise and courageous decision. I hope that today's conference will be a resounding success, and hopefully it can rekindle international cooperation and exchange in the field of laws and institutions that have been practically put on hold by the global pandemic. Thank you very much.
Thank you very much. Now let me invite today's keynote speaker. I'm pleased to introduce Professor Asif Qureshi, Korea University School of Law. Professor Qureshi has been Professor of International Economic Law at Korea University School of Law since 2012. Before that, he was professor at the University of Manchester Law School and a barrister at Clarendon Chambers in London. Currently, he is a member of the ILA Committee on the Rule of Law and International Investment Law and the ILA Study Group on International Tax Law. The title of the keynote speech is Americanization of the International Economic Order, an Asian Perspective. Please welcome Professor Qureshi.
Thank you very much for that introduction. I'm truly honored and privileged to be speaking as a keynote speaker today here. And I congratulate the organizers of this conference for managing to meet the challenges of a conference in these trying times. My focus is on the Americanization of the international economic order, and I think it is an appropriate topic for a conference with a theme like fading borders, because the Americanization of international economic law both underwrites and challenges our sense and notion of frontiers and borders, especially in the light of the US-China trade war. And my talk on the Americanization of international economic law is set against the background of the US-China trade war. Why is it important to focus on the Americanization of the international economic order? There are various reasons for this, which I think we are all familiar with, but I will just go through them. It is the case that insofar as the international economic order is concerned, the United States has been very proactive right from the beginning, from the origins of the modern international economic order as we know it from the times of the Bretton Woods, and of course increasingly now in its involvement in the shaping and changing of the world trading order. The size of the US economy is quite staggering, and countries in Asia, in particular, small, medium, and large economies must and have to contend with the challenges posed by such a big economy. And for those reasons, it is important to understand US law on foreign economic issues, as many multinational companies from this region, for example, Huawei and TikTok, have discovered to their surprise that it is not enough to know the law of China or the law of the World Trade Organization. It is also important to know the US legislative system as it affects international economic issues. Additionally, the US has made important contributions to domestic law via its international engagement, and many of us, many countries in the Asian region have emulated legislative practices from the United States. So there are important considerations here that compel us to actually focus on the US economy, but also as lawyers, US law. My interest, of course, is from the legal perspective, and therefore, when I talk about the Americanization of the international economic order, I'm actually talking about the normative changes that the US brings and has brought about and can bring in the domestic legislation of countries, as well as changes in international economic organization, which in turn bring about changes at the national level. Americanization, as we are discovering now, is not necessarily to be equated with globalization. It has contributed to globalization, but it is not necessarily to be equated with it, nor indeed with the idea of the market as a way of resolving economic issues on its own. So how is it that this Americanization of the international economic order is taking place, has taken place? At the disposal of the United States, various venues and forums and opportunities are available. What I've listed here are some of them. The United States is very active, has been very active in its engagement in international organizations. The US law, as we know and understand, has been transplanted, not just in international organizations and the practice of international organizations, but also in the domestic laws of countries across the world and in Asia. The US has been historically very active in engaging in imposing extraterritorial measures which affect outside individuals and companies, in particular, as we are seeing currently, in the field of export controls and historically in the field of competition law. The US also has, through international trade agreements, free trade agreements, as well as unilateral trade concessions that it has given to countries, has brought about changes in the domestic legislation of other countries. And finally, in the context of specifically in the context of the domestic US legislation, the US has an array of measures which enables it to monitor the trade practices, economic practices of other countries. And the most famous or infamous is the Section 301 US Trade Act, which the US uses in order to identify what it terms as unfair trade practices and take action against countries which are considered to have engaged in unfair trade practices. The US also has its eyes on how specific countries have regulated intellectual property rights, and therefore it has a provision called Special 301. And again, through this provision, it monitors the regimes of intellectual property protection of different countries that are of interest specifically to it and its exports. Under the 1988 and 2015 US legislation, the US is concerned about currency manipulation and also the macroeconomic policies of other countries. The countries that it monitors are those countries which have a certain threshold of exports to the United States and or are engaging in what it defines as currency manipulation. This is an annual process, and it focuses on a number of countries in this region, China, Japan, Korea, on an annual basis. And it embraces not just the currency policies of these countries, but also their macroeconomic policies that the countries have. And it involves ultimately, through Section 301, the application of sanctions if the states in question are not complying with the US view of what constitutes a currency exchange manipulation or macroeconomic policies that affect and impinge upon the US trade deficit. And finally, particularly of late, the US concerns in national security field. The US legislation, Section 232 of the Trade Expansion Act of 1962, defines national security not just in the traditional sense of that concern, but it also conflates economic concerns as national security concerns, and including the effect of foreign trade practices on domestic industry and unemployment. So the national security concern is very widely defined in the US trade practice. And here again, countries that violate or come under the measures set in that legislation have suffered consequences, can suffer consequences. So those measures, those processes by which the US is able to influence the international economic development of the normative development of international organizations as well as domestic laws of countries. The underlying themes of these are essentially, from the point of view of law and legal analysis and scholars, is the relationship between economic power and the rule of law, and failing that, I guess, or how the instruments of power that are used by a powerful economic entity can be managed, should be managed in the international context. My talk is titled Americanization of the International Economic Law from an Asian Perspective. But of course, Asia is not monolithic. Politically, there are countries that are, have different orientations, and the perspectives of these countries is varied. However, almost all, I think I can safely say, Asian countries prefer a multilateral approach to resolving international disputes and dealing with international economic problems. I think also that all Asian countries would want economic power to be embraced by the rule of law. So I'm going to just delve on two aspects of this question in terms of the relationship of economic power and the rule of international economic law against the background of the current trade war between China and the United States. Firstly is the resolution of economic disputes, of trade disputes, through the World Trade Organization. As we are all aware, the United States has essentially paralyzed the appellate body of the WTO, and its approach to reform of dispute settlement comes from an advocacy for flexibility in the way in which disputes should be resolved. And this advocacy for flexibility in the way states should resolve disputes is echoed by quite a number of very eminent international trade lawyers, for example, who have propounded and preached about the idea of efficient breach, an economic concept in cost-benefit analysis, the idea of honorable disobedience when it is necessary in order to bring changes in the law, and lately by one American professor, the idea that we should accept and acknowledge and bow down to the logic of power, and that is both the U.S. official policy and the discourse amongst a number of American economists are at idem on this. I don't think one needs to delve too much on those standpoints. They are not cogent arguments to make. The idea that there should be preferential treatment for a superpower in the way a dispute is resolved is simply not a tenable position for anyone to make. Indeed, even the United States, in its formal postures, engages in legal discourse, as we've just recently seen with the panel decision that has deliberated on the US sanctions imposed on China, that the US actually engaged in putting forward its case in front of a panel, although to its cost in the case. Decision-making in international economic powers, in international economic organizations takes cognizance of the fact that superpowers, if you like, or powerful nations need to have a greater participatory role in the decision-making. So the IMF, as you know, has the weighted voting system to accommodate those power differences between states, economic differences, and also now the practice in a number of international organizations, including the World Trade Organization, of consensus decision-making. As we have seen in the United States, because of the consensus decision-making, has exercised its veto and managed to sustain that veto in the context of the appointment of judges in the appellate body of the WTO. Should we just accept that, or can we engage in legal discourse with respect to the exercise of that veto power, albeit seemingly under the rules of the WTO decision-making processes? I do not think so. I think that the exercise of vetoing appointments in the WTO, the way in which the US has engaged in that, constitutes an abuse of power, and it has resulted in denying member countries of an important benefit, namely the resolution of their disputes through due process and an appellate body process. The denial of a benefit in the WTO law warrants compensation, warrants sanctions, warrants the taking away of measures to negate that veto. So both in the context of the dispute settlement and the context of the way in which decisions are made in international organizations and the WTO, the one thing that has come across is that we do need to address upfront the fact that when there is a superpower, what kind of architecture we should design so as to accommodate it within the system, as well as to try and rein in some of its practices that we may consider as being acceptable. If the elephant is in the tent, then we need to talk upfront about that. How can we talk upfront about that, and what can we do about that? I mean, I'm very much a positivist, an optimist insofar as the powers of the rule of law are concerned, and really power on its own has to embrace the rule of law if it is not just to be a transitory expression of power. Ultimately, power has to have moral authority, has to have legitimate authority, has to have legitimacy in terms of the rule of law if it is to sustain itself. And states recognize that. States recognize that they have to design an international economic order that takes into account the differences in the capacities of the participants in that order. So economic power facilitates the advent of trade wars, and trade wars are conducted through the instruments of tariffs, quantitative restrictions, through the use of currency wars, through the weaponization of a reserve currency, for instance, or the threat of the weaponization of a reserve currency. It may be difficult to definitely determine the legality of trade wars in a meaningful way, but we can, of course, focus on the responsibility that ensues from a trade war. Those who proclaim a trade war must realize and are presumed to understand that in modern day, if you engage in a trade war, you have to engage in that trade war responsibly, that there are certain responsibilities. In the same way as in the context of law of wars, the use of force, international humanitarian law has developed, has evolved, albeit with its shortcomings. Nevertheless, we now have a reasonably well-structured normative framework that goes by the rubric of international humanitarian law. So regardless of the question of legality of the measures or the trade war, we can certainly talk about the fact that the instruments of trade war have an impact on innocent victims, innocent states, and individuals within a state. And therefore, there has to be a count of proportionality, reasonableness in the way these instruments are used and applied in a trade war. There is a case, in my view, that the international humanitarian law can be drawn from for the establishment of a code of conduct in the context of wars that are in the realms of economics alone. So in conclusion, I think I have gone past my time. In conclusion, I would say that power, if it is to be sustainable, has to defer to the rule of law, and that there are that we do not need to be reconciled to the logic of power, that we can, in fact, address power, albeit softly, albeit in a time-consuming fashion, with respect to various measures that can be implemented in the design of a new international economic order, since we are heading towards that, to ensure that there are inhibitors in the system, to ensure that there are checks and balances in the system, to ensure that there can be collective responses to the way in which power is used by a superpower. My talk is not, by the way, just about, it is not about the United States. I'm, as an academic, interested in the challenges that are posed in accommodating any superpower in an international economic order. And the underlying message that I want to make is that we have to talk about this upfront, and if we talk about it upfront, we can come with good answers. Thank you very much.
Thank you very much. Now, at this point, let me remind you that you can watch this conference at alinevent.com. But if you experience access problems due to heavy traffic at alinevent.com page, then please go to YouTube and search for Alin Conference. Then you can also watch this conference on YouTube, and then also you can leave your comments or questions in the chat box of the YouTube channel. And you can leave your questions, and then those questions will be answered at the end of the conference for the Q&A session. And if your answers are not, if your questions are not answered due to time limits, then we will make sure that we will send you the answers to your registered emails. Now, we are going to proceed with the session 1 on migration and trade. And I would like to introduce the moderator of session 1, Dr. Ji-Hoon Kim, Director of Korea Legislation Research Institute. Please welcome Dr. Ji-Hoon Kim. From here, Dr. Ji-Hoon Kim, the moderator of this session, will take over the stage and then run the session 1 on migration and trade.
네, 안녕하십니까?
Ladies and gentlemen, as I've been introduced, I am Director Kim Ji-hoon of Korea Legislation Research Institute. We will now begin session 1 of the international conference. The topic of session 1 is number 1, people migration, and number 2, industry trade. So these are the two major topics that will be covered in session 1. We have one presenter and one discussant for each topic, which means 2 presenters and 2 discussants in total. So let me begin by introducing the topic for the first presentation.
So topic 1 is people and migration. We are happy to have Professor Sivanandam Sivakumar from the Indian Law Institute who will present on this topic. And the discussant will be Vice Director Pham Thi Thuy Na from the Institute of State and Law at the Vietnamese Academy of Social Sciences. So Professor Sivakumar will go ahead with your presentation first, please.
Friends, good afternoon and greetings from India. Hope you and your loved ones are doing well and taking necessary precaution to tackle this pandemic. Take good care of yourself, your family, and be positive. With positive energy, we can conquer this disease very soon. Take care, stay safe, and stay healthy. It is my proud privilege to participate in the Alin International Conference on Laws for Fading Borders in Asia, organized by Korean Legislation Research Institute and Asia Legal Information Network at Seoul in virtual mode. I am grateful to Mr. K. Kong Kim, President KLRI, and all members of KLRI, especially Mr. Hyo Young Kong and Ms. Yan An, for giving me this opportunity to participate this event once again. Also, my sincere thanks to my fellow fraternity members of Alin. Dear moderator and discussant of my session, Professor Han Thi Tu Nag, Vice Director, Institute of State and Law, and fellow speakers and dear participants of this conference, very good afternoon once again. In this session on people, migrant workers, immigration, I am going to speak on migration and constitutionally protected class in India. Let me give an overview of my country. India has completed 70 years of its working of constitutional governance since its adoption 1950. The journey of young republic has survived the turbulence of emergency as imposed in 1970s, continued insurgency in its bordering state with international boundaries. We accommodated more than 100 amendments to the Constitution to meet our changing needs. It's again remained a basic fact that in all these years, the basic principles of constitutional governance remain intact, like free and fair periodic election, independence of judicial system, separation of powers, power of judicial review, accountability of executive to the parliament or respective legislatures, etc. Under the constitutional scheme, certain class of people like women and children, socially and educationally backward classes of citizens, scheduled caste and scheduled tribe, minorities either religious or linguistics, Anglo-Indians, etc. are recognized as special class or group of citizens who are bestowed with the special rights of special protection. Citizens who are bestowed with the special rights of special protection. In essence, our Constitution warrants a positive action from the state due to the past practices and prevailing socio-economic condition and vulnerabilities. Such special protection to the indigenous people or aboriginals to this land, often referred as son of the soil, in the Constituent Assembly while framing our Constitution, remains one of the basic features of all the modern progressive constitutional democracy. A cursory glance to the constitutional scheme of Canada, South Africa, United States of America, New Zealand, Australia reflects a similar approach in designing the constitutional protection to such class of citizens. Coming to migration, the term migration as defined in Webster's dictionary, I quote, the act or an instance of moving from one country, region to settle in another, or an act of moving from one area to another in search of work, unquote. Again, if I am quoting Ernest Ravenstein, an English geographer, he opined that, I quote, migration was governed by push-pull process, that is, unfavorable condition in one place, oppressive laws, heavy taxation, etc., push people out, and favorable condition in an external location pull them out, unquote. Thus, migration is the movement of people from one area to another across region looking for studies, livelihood, employment, opportunities, accommodation, sometimes for security. And it is happening in India too. Human migration means the permanent change of residence by an individual or group. It excludes such movements as nomadism, migrant labor, commuting and tourism, all of which are transitory in nature. Migration falls into several broad categories. Firstly, internal and international migration may be distinguished. Within any country, there are movements of individuals and families from one area to another. For example, from rural areas to cities, and this distinct from movements from one country to another. Second category may be voluntary or forced. Most voluntary migration, whether internal or external, is taken in search of better economic opportunity or housing. Forced migrations usually involve people who have been expelled by government during war or other political upheavals, or who have been forcibly transported as slaves or prisoners. Immediate between these two categories are voluntary migration of refugees fleeing war or natural disasters. Whatever may be the reason, the migration is not that simple and raises a lot of concerns. In a diversified country like India, which has diverse geographic features coupled with indiscriminate, unequal development, great urban-rural divide in terms of opportunity, employability, as well as the federalism as one of the basic features, the migration or the movement of various class of people is inevitable. Recently, in 2018, the Supreme Court of India, a constitution bench, dealt with one constitutional issue through Bir Singh versus State of Delhi Jal Board case. The issue is implication on rights guaranteed under Part 3 of the Constitution to scheduled castes and scheduled tribes when they choose to migrate from one state to another or any union territory in a federal setup like India. No doubt, the scheduled caste and scheduled tribes are a constitutionally recognized protected class of citizens under Article 15, 16, 46, 341 and 342 of the Constitution. As Constitution also guarantees certain inalienable fundamental freedoms as incorporated under Article 19(2) of the Constitution, including right to move freely throughout the country, to reside and settle any part of the territory of India, and to practice any profession or to carry any occupation, trade, or business. So, how these special rights and protection, which has been accorded to such class of citizens, get affected in case of migration within the country, that is from one federal unit to another in search of job, occupation, vocation, trade, or employment under the state. The majority judgment headed by Justice Ranjan Gogoi in Bir Singh case identifies the root cause of according such constitutional protection in the following words. I quote, "The caste system in India, which is the bane of a just social order, has a long history which can be traced to the earliest time. Ancient Hindu religious scriptures refer to the practice. Division of society based on birth and the calling profession of a person has continued to dominate Hindu thinking and way of life, and is perhaps one of the thorny problems inherited by British administration, which had tried to resolve the same by giving legal recognition to what come to be termed as depressed classes. Such recognition was in the form of protective regime, which extended to representation in the legislature and in the service under the state. The fact of historical subjugation and oppression of a sections of society cannot be healed in the 70 years of our constitutional governance or constitutionalism. The menace of caste system continues to be practiced in every nook and corners of India, despite having Article 17 abolishing untouchability and plethora of legislative framework in present day also. The benefit of reservation in employment, promotion as well as consequential seniority is accorded to the scheduled castes and scheduled tribes as a matter of right under Article 16 of the Constitution. SC and ST are identified through a presidential notification for each state under Article 341 and 342 of the Constitution. In 1989, the Supreme Court in Mary Chandrasekhar Rao lays down that the reservation benefit ceases to be available to the SCs and ST upon migration from one state to another. The decision of Mary Chandrasekhar seeks to cater the local needs in first state employment, meaning thereby opposed to the idea of national integration. The dictum of Mary Chandrasekhar Rao belittle the fundamental rights and protection accordance to SC, STs as class under Article 17 and Article 19(1)(d) of the Constitution. As migration involves the movement of people, the policy of not extending benefit of reservation creates an additional barrier to recognize the fundamental right guaranteed under Article 19(1)(d). Subsequently, in 2016, another constitutional bench of the Supreme Court in Nagaraj case makes the right guaranteed under Article 16.4 and 16.4a, 16.4b as enabling provision with a discretionary remedy. The founding fathers of the Constitution could never have dreamt of having a provision in Part 3 of the Constitution as non-enforceable, leaving it to the discretion of the state. Further, the decision of Nagaraj seeks to borrow the theory of enabling rights from the majority judgment, a 9-bench judgment of Indira Sahani case, and approves the same. Here, one may say the approval of dissenting view in Nagaraj case as well as the theory of enabling rights with a discretionary remedy is a kind of fraud on Constitution itself. It is a welcome aspect of the recent above mentioned case, that is Bir Singh case. It makes the Pan-India reservation rule in force for the service under National Capital Territory, that is NCT of Delhi, and held the same in accord with the constitutional scheme relating to services under Union and the state and Union territories in India. However, the recent constitutional bench decision only decides the case of NCT Delhi as Union territory and leaves the question of law open for Union territories including Pondicherry and Chandigarh. The ideals of fraternity and national integrity as preambular goal are less emphasized than other expressions like secularism and socialism. Although the Supreme Court ought to have revisited the dictum of Mari Chandrasekhar Rao in the light of 77th, 81st, 82nd and 85th constitutional amendment, as these amendments are subsequent constitutional developments. As the National Capital Territory represents a miniature of India, due to its unique constitutional provision under Article 239A of the Constitution, the judgment has a vision and is futuristic in nature. Though movement and migration of people in any given civilization is inexorable, the counters of basic rights guaranteed under Part 3 of the Constitution must not be dependent upon geographic boundary of the state in a federal structure. In some other situation, if any person has fraudulently claimed to belong to a SC/ST, has thereby obtained an employment, he would be disentitled from continuing in that employment. The rigorous aspect of this disentitlement conclusion has been diluted in some instances, like Shalini versus New English High School Association in 2013 and Kavita Solanki versus State of Maharashtra in 2012 by the Supreme Court. I would like to conclude an overview of the relevant constitutional protection scheme to the constitutionally protected class in India. The conferment of certain fundamental rights or group of rights and representative rights to realize the goals of social, political and economic justice within a constitutional framework gets impacted by the current interpretation of the Supreme Court, especially when the people, that is constitutionally protected class, migrate from one state to another state in case of interstate migration. This further has an impact on the idea of fraternity, national integrity, and the concept of one nation, that is, in our language, Ek Bharat, Shresth Bharat. Thank you for patient hearing.
네, 시바쿠마 교수님 발표 감사합니다.
Yes, thank you very much, Professor
교수님께서는
Siva Kumar, for your
발표에서
presentation.
인도
So we heard
국가
about
내에서의 이주를
mostly
말씀해 주신 것
internal
같고요.
migration within India.
관련된 이 쟁점으로는
And then as some
헌법상
issues,
인도
we heard about
헌법상
how in
보호
the Indian
대상에 관해서
constitution,
규정이 있고
there are
그런
certain
보호 대상에
classes
적용을
that
받게
are
되는
subject to
클래스
protection.
계층이
So protected
한 지방에서
class,
다른 지방으로
if they
이전했을 경우에
migrate from
원래
one
받게
region to
되던
another,
어떤
would
혜택이나
they still
조치들이
continue to
여전히
benefit from the
유효한가에 관한
reservation
인도 판례를
benefits
중심으로
that they
설명을
previously did?
해주셨고요.
And we heard
발표의
about the
취지는
different
이런 보호
court
조치들이
rulings.
계속 인간의
And so
이주에 의해서 영향을 받지 않고 인도
protection,
헌법에서
the benefits,
명문으로 규정하고 있는
they are
내용들이
stipulated and
구현될 수
protected
있도록
by
돼야
the letter
된다는
of the
취지의
Constitution.
발표이신
And
것
I believe
같습니다.
that the professor agrees that they should be
카스트 제도의
respected
문제점과 관련해서도
irregardless of whether
말씀해 주셨고요.
a
왜
person
이주가
migrates
있게
and moves
되는지
to
인도의
another
특수한
region.
상황,
We heard about the special
발전의
circumstances in
불균형이
India, how there's a
있다거나
lot of
지역 간 차이가 있다거나
imbalance
이로
in terms
인해서
of development,
기회나 교육이나
which
취업에
is why many
있어서
people may
더
choose to
나은 곳으로
migrate, try
이주하고자
to
하는
go to a place with better conditions, for better opportunity.
행위에서 기인한다 이런 말씀까지
And
같이
we heard
주셨습니다.
also
네, 이
about that
발표에
as a
대해서
backdrop.
베트남 국가법
Thank you very
연구소
much. Now we will welcome
부부장이신
Vice Director
부소장님의
Pham Thi
토론을
Thuy
듣겠습니다.
to make some comments as a discussion.
Guests and participants of the 16th ALIN meeting. My name is Nga. I came from Institute of State and Law in Vietnam. 2020 is a special year when the COVID-19 brings great difficulties to all of us, changing the ways of working and organizing annual meeting of ALIN members. Please accept my best wish to all participants and wish to the 16th ALIN meetings a success. I would like to go back to discuss the article prepared by Professor Siva Kumar, Law Commissions of India. The title of the article is Migrations and Constitutionally Protected Class in India. First of all, it is my great pleasure to read and discuss this interesting paper, which provides a lot of information about the issues of ensuring the rights of scheduled castes and scheduled chiefs in the context of interstate migrations in India. The articles also shows changes in the approach to ensure the rights of socially and educationally backward class of citizens through constitutional interpretations and applications by the India's Supreme Court in specific cases. The articles explains India's acceptance of the difference in fundamental rights of socially and educationally backward classes of citizens due to the difference in socio-economic development levels among states' regions. I also pay special attention to the viewpoint given in the article, that is, the need for a uniform, justice, to be adopted for giving benefits to the members of socially and educationally backward class of citizens. Now, I have two questions for Professor Sivakumar. The first question: how is the executive accountable to the parliament and respective legislature in deciding the list of scheduled castes and scheduled chiefs? The second question: could you please specify, give more information about the rules of course in protecting the rights of individuals who are the members of socially and educationally backward class of citizens when they move across states in India, as this situation may cause them to lose their status of members of constitutionally protected class. Thank you for your attention.
네, 토론자 토론 잘
thank you
들었습니다.
very much for the questions
토론을
for the professor as well.
질문을 위주로
So I think
말씀을 해주셨는데요.
they were mostly directed as questions for the presenter.
해결을 하고 가는 게
So
어떨까
I
합니다.
think it would be
연결이 될까요?
best to connect with Professor Sivakumar. Can we do that
시바쿠마
to
교수님,
hear his
방금
answers
우리
first?
토론자께서
So,
질문을 두
Professor,
가지 주셨습니다.
the discussant gave you two
행정적인
questions just now.
부분과 법원에서의 역할,
First about
이렇게 크게 두
the
가지
executive
셨는데요.
accountability, and
지금
then
바로
second, the role of the
답변을 좀
courts.
해주시면
We would
감사하겠습니다.
appreciate if you could provide your answers right now.
Yes. Thank you, discussion, for asking the very pertinent questions. May I answer for the first question? I repeat, the first question is, how is executive accountable to the parliament and respective legislatures in deciding the list of scheduled castes and scheduled tribes? The answer, the constitutional principles of check and balances and accountability of executives to the parliament and respective legislature is inbuilt, and the express provision has been provided in the text of Indian Constitution itself. The principles of collective responsibility, Article 75(3) of the Constitution prescribes that the Council of Ministers shall be collectively responsible to the House of the People. House of the People, either the Parliament or the state legislatures. The object of collective responsibility is to make the whole body of persons holding the ministerial office collectively or vicariously responsible for such acts of others are referable to their collective violations. Further, the President of India, who is also the executive and head of the Union under Article 53 and part of the Parliament under Article 79, as well as the power where the President may require the Council of Ministers to reconsider such advice either generally or otherwise in Article 74 of our Constitution. Secondly, due to periodic election, it is every 5 years the same executive, that is, who are all part of elected representative members of legislature, has to seek a fresh mandate, that is a fresh election from the people in case of parliament as well as the respective state legislature as well. In India, free and fair election along with periodic election has been declared as one of the basic features of our Constitution. Similar is the provision of the state legislature. You can find in state and the state executive as enshrined under Article 164(2), 168, 167C and Article 160 as well. As this list is preferred pursuance of power conferred under Article 341 and 342 of the Constitution. It is a specific power entrusted to the President of India in consultation with Governor with respect to that state. A glance and debate which took place in the Constituent Assembly debate at the time of adopting the Constitution, chaired the drafting committee chairman, Dr. B.R. Ambedkar, said, I quote, "The object of these two articles, as I stated, was to eliminate the necessity of burdening the Constitution with long list of scheduled castes and scheduled tribes. It is now proposed that the Parliament, in consultation with the Governor or the ruler of the state, should have the power to issue a general notification in a Gazette specifying all the caste and tribes or group thereof deemed to be scheduled caste and scheduled tribe for the purpose of the privileges which have been defined for them in the Constitution. The only limitation has been imposed is this, that once a notification has been issued by the President of India, which undoubtedly he will be issuing in consultation with and on the advice of government of each state, thereafter if any elimination was to be made in the list, so notify, or any addition to be made, that must be made by the Parliament or not by the President. The object is to eliminate any kind of political factors having a play in the matter of the disturbance in the schedule or published by the President. I unquote. So the constitutional scheme is very clear on preparation of this list for the constitutionally protected class, that is scheduled caste and scheduled tribe. May I answer quickly the next question also? The next question, could you please specify the role of courts in protecting these rights of individuals who are members of socially and economically backward class of citizens when they move across the states in India? The fear has been rightly raised by this question by the discussant. When a person X who belongs to the scheduled caste, when migrates to other states in India, he loses his protection or status as scheduled caste with respect to the state or rest of the India. And it has been interpreted and read by the courts in India, including the Supreme Court of India, such only, but the reality and fact upon the migration that the stigma, backwardness, inferiority, and vulnerability along with the status of scheduled caste and scheduled tribes migrates with such person wherever he goes. Because of this backwardness, the stigma and status is due to his birth, and it moves from generation to generation. The courts in India, while interpreting such beneficial and social objective behind such provision, has just interpreted in mechanical manner, not taken realistic, pragmatic approach.
시바쿠마 교수님.
It only cite.
교수님.
Professor?
네, 죄송합니다만
I'm very
저희가
sorry,
예정된 시간이
we do have very
많이
limited time, and
지체되어서요.
I'm afraid
Okay,
I
am finishing. So it only cites reasoning local needs and local backwardness of that particular state. So the decision in action committee, as well as I mentioned the Mary Chandrasekhar Rao, requires reconsideration, and the constitutional courts of India has to rectify our own mistake, which defeats the purpose and objective of conferring status of constitutionally protected class. Thank you very much. Sorry for taking long time.
네, 열띤
Thank you so much for the very enthusiastic
궁금한 게 많았었는데요. 시간 제약이 있어서
We are
충분히
so
드리지
curious
못한
to know
점
more,
죄송합니다.
but I'm so
좀
sorry for
미진한
not being able to
부분은
give you
우리
enough
메일을
time
통해서 또
to
주고받을 수
cover
있고요.
everything that you had
아니면 또
prepared.
저희 사무국을
We
활용하시면
could actually
또 더 자세한
discuss further
답변을
through
드리도록
email,
하겠습니다.
perhaps share email,
이상으로
and
첫
then we
번째
can also contact you
주제와
for
발표와
future
토론을
follow-up through our
마치겠습니다.
secretariat.
이어서
So we will have to
바로
move on
두
to the
번째
very
발표로
next presentation
들어가겠습니다.
for
두
the
번째
day.
발표는 주제가 인더스트리 트레이드이고요.
The topic of the next
발표는
presentation
우리
is
마카오
industry
대학의
trade. Our presenter
알렉산더
is Associate
스베틀리치니
Professor
교수님께서
Alexander
해주시겠습니다.
Svetlicini of the University
주제는
of Macau,
Fading
Faculty
Borders
of
for
Law.
Trade and
The theme of the
Investment이고요.
presentation is Fading Borders for
이
Trade and
발표에 대한
Investment.
토론은
And
한동대학교의
this will
조혜신
be followed by
교수님께서
discussion by
해주시겠습니다.
Professor Cho Hae-shin of Handong University, Faculty of Law.
스벨틀리치니 교수님 발표
Professor
부탁드리겠습니다.
Svetlicini, please begin your presentation.
To 2020 International Conference. My name is Alexander Svetlicini, and it is my pleasure to speak to you today on the role of the state-owned enterprises under the ASEAN regional competition policy, under the general theme of our conference, which is laws for fading borders in Asia in the field of trade and investment. I would like to begin my presentation by highlighting several reasons why it is especially important to discuss the role of the state-owned enterprises today. We have all witnessed the rise of protectionism and populism in the state economic policies around the world. This has also affected the discourse in the field of competition law, where different stakeholders called for greater consideration of the industrial policy and other public policy objectives, for the protection and promotion of the national champions, which often are state-owned enterprises. We have also witnessed new regulatory barriers for SOE operations abroad, such as foreign investment screening regimes based on the national security and public order, as well as a screening for foreign subsidies that companies might have received in their home countries. The rise of China as an economic powerhouse and the increase of the presence on the international markets of its SOEs have also created new challenges for competition law enforcement, for example, in the field of merger control when screening the corporate acquisitions of the Chinese SOEs. Finally, looking into the post-COVID-19 economic recovery period, the governments and other stakeholders begin to debate the role of the state-owned enterprises and the private companies in the process of economic recovery, which is going to be a litmus test for competitive neutrality and the level playing field around the world. Now, when we speak about the state-owned enterprises in competition law, we speak of them as undertakings, which are active on certain markets, supplying or buying goods or services. So we can say that the competition law is in fact ownership neutral, without distinguishing who is the owner of the company, but rather focusing on the economic motivations of its market behavior. As such, we can say that competition law is based on the principle of competitive neutrality, which means that it does not discriminate between different types of companies based on their ownership. Nevertheless, despite this competitive neutrality, there are certain concerns which are caused by the specifics of the SOEs. To name just a few of them, public policy functions of the SOEs, along with the commercial objectives, affect their decision-making and affect their behavior of the markets, something that has to be taken into account when applying competition law to the actions of the SOEs. Also, because of the state support granted to the SOEs, it might cause a distortion in the level playing field, because in this way the SOEs will have a more advantageous market position in relation to private companies that do not receive the same kind of state support. State-owned companies also frequently operate as monopolies or in a highly regulated sectors where they are subject to the sector-specific legislation, which also regulates competition, and there we might have a overlap or conflict between applying competition law and sector-specific legislation to the activities of the SOEs. Finally, there is a number of substantive and procedural challenges of applying competition law to the SOEs that we will address later in the presentation. When we start speaking about the role of the SOEs in ASEAN, I would like to start from reminding you of the objective of the ASEAN economic community, which is the creation of a single market and a production-based, a highly competitive economic region with equitable development, economic development, and also fully integrated in the global economy. For the achievement of this objective, the ASEAN Economic Community Blueprint 2025 have stated that level playing field for all firms through the effective competition policy must be ensured. So, at least on paper, the ASEAN Economic Community foundations provide for a level playing field or non-discrimination between state-owned and private companies. Now, we should also mention here the Asean Way of Cooperation, or Asean Way of implementing the policies that they have agreed on. It is based on unanimous consensus, and also characterized by the lack of supranational rules or enforcement authorities that can ensure the implementation of those objectives or commitments. So basically the ASEAN way largely depends on the will and the commitment of the individual ASEAN member states to implement certain objectives in their policies and legislation. Now, when we come to the ASEAN competition law and policy, we should mention the ASEAN regional guidelines on competition policy, which have been issued in 2010, and they established a number of principles that are recommended to the ASEAN member states to follow. These principles include competitive neutrality, something that we have already addressed. Another principle is that the SOEs, in the same way as other types of companies, should be covered by competition law. So competition law should apply to the behavior of SOEs in the markets. But at the same time, the guidelines allow member states to make certain exemptions from competition law based on the public policy concerns. The ASEAN Economic Community Blueprint 2025 have listed a number of goals of implementing these competition law and policy objectives. One of the goals was the adoption of competition legislation in all ASEAN member states. Another objective was to strengthen the capacity of competition authorities to enforce those competition legislation in practice. Another objective was to establish certain regional competition arrangements which would allow competition authorities from ASEAN member states to interact and cooperate. The blueprint also calls for greater harmonization of the competition policy among ASEAN member states, and also enhancing the role of the competition law and policy in the general economic statecraft of the ASEAN member states. So, where the ASEAN member states stand today in relation to achieving these objectives? Here we can see on the slide the summary of the competition legislation and competition authorities in the ASEAN member states. We can see that by now all of the ASEAN member states, except for Cambodia, have adopted their comprehensive competition legislation. And established or are in different phases of establishing their competition authorities. Following this general presentation, I would like now to look into the ways how the ASEAN member states have decided to treat the state-owned enterprises under their national competition legislation. The competition ordinance in Brunei, for example, allows for sectoral exemption when competition law will not be applied to certain types of activities, which allows for a de facto exemption from the SOEs of the SOEs that operate in these sectors or engage in these activities. In Cambodia, as it was mentioned, there is still no comprehensive competition legislation, so it is too early to address how this country will handle its SOEs under the competition law. In Indonesia, there is a centralized control over the SOEs concentrated in the hands of the specialized ministry, but there is also a large number of the locally or regionally controlled SOEs. In Indonesia, the SOEs play a very important role in the national industrial policies, and this significantly increases the state intervention in the market and in the way how the SOEs operate in these markets, which of course affect their competition with private companies. Laos is currently ongoing an SOE reform where the government tries to make them to perform better economically. However, the competition law still envisages certain exemptions based on public policy, which can be expected that SOEs would be covered by such public policy exemptions in certain sectors. In Malaysia, where also there is a certain degree of the centralized SOE control, there are different sectors which are exempted from the application of the competition legislation and have a specific sector-specific competition regulations which apply to those sectors. As a result, some SOEs are not being subject to competition law enforcement. In Myanmar, SOEs dominate several important markets, and the competition law and its enforcement is only at the initial stage. So here is also quite early to speak about the ways how the competition law in this jurisdiction would apply to its SOEs. Similar situation in the Philippines, where the competition authority has already accumulated certain enforcement record, but there are a little evidence on how the competition law would be applied to the SOEs, which actually receive a significant state support, which leads to distortion of market competition on several markets where the SOEs compete with private companies. In Singapore, there are sectoral competition provisions, which basically exempt certain sectors from the application of the competition law and have sector-specific competition rules applied there. Nevertheless, the Singapore Competition Authority has already shown that it is capable of applying competition law to the anti-competitive behavior of the SOEs. Thailand has chosen an exemption of SOEs from application of competition law. It also has sectoral exemptions, which cover certain SOEs which were subsequently privatized, and as a result, it basically preserves the market dominance of the current or former SOEs in a number of markets. Vietnam is also undergoing an SOE reform, where the government attempts to restructure its SOE sector, making more economically efficient. However, the SOEs still exert a significant influence on the regulators, including the competition authorities, which results in the lack of effective enforcement of competition rules against the anti-competitive behavior of the SOEs. So to summarize, the situation in the ASEAN member states in relation to applying competition law to the state-owned enterprises, it's very diverse. There is a large number of sectoral exemptions in different ASEAN member states, which means that the competitive neutrality principle is not recognized in all of the ASEAN member states, as SOEs continue to be exempted from application of the competition law in certain countries. In several ASEAN member states, SOEs are seen as drivers of state economic policy, so we can expect still the continuous state support, which will strengthen their market positions. At the same time, we have witnessed ongoing SOE reforms, where certain ASEAN member states try to reform their SOEs and make them market players on the same footing with private enterprises. There we can expect a more competition law enforcement towards SOEs. And then generally there is a very varying degree of antitrust enforcement, with some competition authorities being more active, some less active, some willing and others unwilling to apply competition legislation to the actions of the SOEs. When we put together these observed tendencies and the goals of the ASEAN economic community, we can underline several ways forward that we can expect in the way how the SOEs will be handled under the competition laws in these countries. First, we can expect, although reduced, but certain degree of harmonization on the national competition laws, especially as the competition law regimes in the ASEAN member states becomes more mature and try to adopt the best practices from other countries. We also see a clear need for establishing some sort of regional cooperation arrangement, at least for those cases which concern cross-border trade, where the competition authorities from different ASEAN member states might find a need to communicate, interact, and cooperate on certain cases. It could also be suggested that the ASEAN member states should consider adopting some sort of common principles for operations of its SOEs, especially for the overseas operations, when the SOE from one ASEAN member state conduct business or invests in another ASEAN member state, where they could influence the competition on the markets. Also, the post-COVID-19 economic recovery might reduce the pace of the SOE reforms, which makes it especially important that the ASEAN countries continue the dialogue in relation to applying competition law to the activities of their SOEs, especially when they are engaged in the cross-border trade in goods and services. So these were my conclusions, which follow from the comparative review of the competition laws in the ASEAN countries and the way how they applied to the market behavior of their SOEs. I thank you for your attention, and I look forward to your questions and feedback and during the Q&A session. Thank you very much.
네, 교수님 발표 감사합니다.
Thank you for your presentation, Professor.
국영기업이 우리 경쟁법에 주는 많은 이슈들을
how
생각해 볼 때
SOEs are affected by the competition law and policy,
특히 아세안에서의
vice versa.
논의를 중심으로 해서
You especially focused on the ASEAN region, and you proposed the need for a regional common principle and regime.
청사진 같은
And
내용들을
also you mentioned the
설명해
ASEAN Economic Community Blueprint
10개국
2025.
정도의 사례를 설명해 주시면서
And you
현재
told us
아세안
examples of
국가들의
10 ASEAN
경쟁
countries and their
정책의
competition law and policies, so
전망에
that we
관한
can
발표
understand
잘
where they are
들었습니다.
today as well
네, 이
as
발표에
where
대해서
they will stand in the future.
한동대학교의
And now we will hear the
교수님으로부터
discussion by
토론을 듣도록
Professor
하겠습니다.
Cho Hae-shin of Handong University.
Hello everyone, nice to meet you. My name is Hae-shin Jo, Associate Professor of Handong Global University. It is my great pleasure for me to discuss on Professor Svetlitsky's presentation. Through the presentation, he raised a timely and important issue that needs to be considered in the context of fading borders and continuous efforts toward cooperation and integration in ASEAN region, and furthermore, Asian region. I have had interest in recent development of each country in ASEAN, which is promising and surprising. This enables us to have a dream to have more intimate collaborations and frequent exchange. Especially, I absolutely welcome a dialogue to find the way to improve competition policy and laws together with ASEAN countries. Here, I, as an honorable discussant for Professor Svetlitsny's presentation, I'd like to ask him to give us some additional comments on this issue. Firstly, I think it is very appropriate and correct that the presenter has concentrated on SOE-related issues in ASEAN, in that they have greatly influenced a national economy in the aspect of not only their essential roles and contributions, but also their potential harms and threats against competition order. I totally agree that proper regulation against their anti-competitive behaviors could be a cornerstone for establishing level playing field in ASEAN economy. However, at the same time, I would like to suggest that we better not to lose positive side of SOE's function, especially considering the fact that many ASEAN and Asian countries have been rapidly developing. It is necessary to make use of SOE's technological and financial strength and public responsibility as suppliers of public service. I believe SOEs still required to play important role in ensuring a basic level of well-being of all people. Also, the transitional process toward competition needs to be step by step. In case of Korea, telecommunication sector had been monopolized by your SOEs for a long period of time under the specialized regulations and authority. In 1990s, the Korean Competition Authority, which is Korean Fair Trade Commission, namely KFTC, began to actively apply the Korean competition law in telecommunication industry, which led to conflicts with specialized regulatory authority. Back then, we had a couple of crucial decisions of the Supreme Court. Through trials and errors, now we may say that competition law has come to take leading position in national economic policies. I think applying competition rules to SOEs should be accompanied with abolishing diverse protective measures, promoting new entries, and adopting structured policies to transit toward competition in major industrial sectors. In this sense, why don't we take a look at an interesting example of China, where, as far as I know, there are specialized regulations against monopolistic conducts of SOEs, namely administrative monopoly, as far as I remember. For a Korean researcher, it seems unfamiliar as we adhere a principle of competitive neutrality that the presenter has mentioned. However, it is worthy of studying to adopt a set of distinctive and separate regulatory framework rather than a sudden, comprehensive, and general application of competition law to handle with SOE's monopolistic behaviors, and gradually improve industrial structure, which have been led by major SOEs. I would like to listen to some comments on this idea from the presenter. Secondly and lastly, I've been impressed that the presenter brought about an ambitious vision for coordinated and harmonized regional competition norms. And I have found that there have been much efforts for the vision in ASEAN, such as 2010 ASEAN Regional Guidelines on Competition Policy and 2025 AEC Blueprint. I hope Korea could join the efforts and dedicate to the vision. I guess the experience of Korean competition law enforcement since 1980 is helpful to ASEAN countries. My second and last question is whether there are any possible and practical suggestions to strengthen the capacities of competition authorities in ASEAN and Asian region overall. I would like to express my gratitude to the presenter for your great presentation, and I appreciate all of you here for listening to my discussion. Thank you.
네, 훌륭한 토론 감사합니다.
Thank you very much for your discussion.
발표자께서 우리 토론자께서 주신
Professor
말씀을 잘
Svetlicki,
들었을 걸로 이해를 하고
now it is your turn to answer the questions that were just asked, as well as any opinions for the comments that were posed. I think you will have about 3 to 5 minutes to speak in the interest of the time. I know that you have a lot to say, but please kindly understand that we have time restriction. Thank you.
Yes, thank you very much. I would like to thank also Professor Cho for providing valuable comments on my presentation. Very briefly, some of the points that she made that certainly deserve some more reflection. So one point that she has mentioned is that we should not forget about the public functions of the SOEs, that they provide goods and services to the respective societies. I would agree that exactly these kind of services and goods are something that should be object of exception or object of exemption from competition rules. Not the whole sector, not the particular enterprises, but the specific services or specific goods provided. So we can say, for example, like services of general economic interest. That's something that definitely can be exempted. She also mentioned that application of competition law should be accompanied by the opening up of those markets where the SOEs operate. I also would agree on that point, and I would say that until the protectionist barriers are removed, there is little that the competition law can do other than constraining some exploitative practices of the SOEs which enjoy monopolistic positions in those markets. But when those markets are open and the support of the state or protection of the state is removed, then the SOEs should be treated in the same way as they are private competitors according to the principle of competitive neutrality. One of the questions that she asked at the end of her presentation, what would be the suggestions how to enhance the capacity of the ASEAN competition authorities? I would draw your attention here on the practice of the European competition network, where 27 competition authorities regularly cooperate, exchange information, discuss cases. This kind of exchange of experiences and best practices is definitely something that would enhance the effectiveness of individual competition authorities and will allow them to adopt the best practices, but also start the discussion that could be forwarded later and brought up at the level of their respective governments and legislators. And that would be the discussion of what will happen if an SOE that receives a state support in a certain country operates in a foreign markets, where it does not provide these public goods and public services. How to address this kind of cases. So certainly the dialogue between the competition authorities could start these discussions and could lead to the adoption of certain best practices and maybe later some kind of common principles that the countries could adhere to. Once again, thank you to organizers for this opportunity to present, and many thanks to Ms. Cho for her valuable comments. Thank you.
네, 훌륭한 답변 감사합니다.
Thank you very much for your answer.
이렇게 해서
With
이
this,
세션에 준비되었던 발표와 토론 모두 마쳤습니다. 심도 있는 논의가 될 수 있게 해주신 발표자,
I would like to thank
토론자께
the
감사의
presenters and the
말씀을
discussants
드리겠습니다.
for
이상으로
insightful
우리 세션은 모두 마치도록
discussions.
하겠습니다.
Thank
감사합니다.
you very much.
Thank you, speakers, discussants, and moderator for the passionate and informative session. Now we are concluding session 1 with this, and I'm going to take 10 minutes break because we are running a little bit behind the schedule, so we're taking only 10 minutes of break. And the next session will start at 3:55, so please don't go too far, but come back to your come back to session 2 on human rights in 10 minutes. Thank you very much. Alin members online, please stay at your desk because we are going to take photos like we did at the general meeting this morning. So please just stay and then look at the camera while we are having the invited guests here up on the stage. 여기 계시는 분들께서는 이 무대 위로 나와주시면 저희 이제 여기 온라인에 계시는 분들하고 같이 사진을 찍으려고 하거든요. 그래서 무대 위로 나와주시면 감사하겠습니다.